The world of NASCAR is no stranger to high-speed drama on the track, but the real fireworks are about to happen in a federal courtroom. An antitrust lawsuit pitting two major race teams against NASCAR itself is finally going to trial, and the outcome could reshape the entire sport. This isn't just about money, it's about power, control, and the very future of stock car racing. Let's break down how we got here. The battle revolves around something called the charter system. Think of a charter as a franchise license for a race team. There are 36 of them in the Cup Series, and owning one guarantees your car a spot in every race, along with a bigger slice of the television revenue. These charters were introduced back in 2016 to give teams some long-term financial stability and asset value. You could buy them, sell them, and build a business around them. The problem? These charters aren't permanent. They operate under a multi-year agreement, and the current one is set to expire. For years, teams have been negotiating with NASCAR for a new deal, and the biggest sticking point has been permanence. The teams argue that permanent charters would make their businesses truly secure, encouraging long-term investment from sponsors and owners alike. If your charter is permanent, it's a real, tangible asset, not just a temporary license that NASCAR could revoke. NASCAR, on the other hand, has refused to grant permanent charters. From their perspective, keeping the charters temporary gives them leverage and control. It ensures that teams perform well and stay committed to the sport. They worry that if charters become permanent, a team could just coast, collecting TV money without putting a competitive car on the track, which would hurt the overall quality of the racing. NASCAR sees itself as the steward of the sport, and they believe this control is necessary to protect its health and integrity. This disagreement has been simmering for years, but it finally boiled over. While most teams reluctantly accepted NASCAR's terms for a new 7-year agreement, two teams held out. 2-3 Racing, owned by basketball legend Michael Jordan and star driver Denny Hamlin, and Front Row Motorsports. Instead of signing the deal, they filed a bombshell antitrust lawsuit against NASCAR in late 2024. Their lawsuit claims that NASCAR is operating an illegal monopoly. They argue that by controlling the charters and refusing to make them permanent, NASCAR is artificially suppressing the value of the teams and preventing a free market from operating. The teams believe that NASCAR's structure gives it all the power, leaving them with all the risk. They've invested hundreds of millions of dollars into cars, facilities, and personnel, but without a permanent stake in the sport. They feel their entire business model is built on shaky ground. The legal filings leading up to this trial have been explosive, pulling back the curtain on the tense, often hostile, negotiations that have been happening behind closed doors. One of the most stunning revelations came from an expert report filed by the teams. It detailed NASCAR CEO Jim France's reaction to a letter sent by Heather Gibbs, owner of Joe Gibbs Racing. Heather Gibbs, a respected figure in the garage, had written a heartfelt letter to NASCAR leadership trying to bridge the gap. She argued passionately that making charters permanent would be a sign of trust and partnership, securing the team's commitment for the long run. It was a plea for collaboration. But according to the court documents, Jim France's reaction was anything but collaborative. The report alleges he read her letter out loud while swearing every other sentence, leading other executives to conclude that her well-intentioned effort had actually hurt the team's cause. This anecdote paints a picture of a deeply fractured relationship, one where negotiation has been replaced by anger and frustration. The lawsuit isn't just about permanence, it's also about a bigger piece of the pie. NASCAR recently signed a massive new television deal worth nearly $8 billion over 7 years. The teams feel that their share of that revenue is not enough to cover their skyrocketing operational costs. They are the ones putting on the show. They argue, and they deserve a larger percentage of the income generated from it. NASCAR counters that it has its own significant expenses, from sanctioning fees to marketing and promoting the sport. As the trial begins, both sides are dug in, convinced they have a winning case. The judge overseeing the proceedings, however, has expressed serious concern, stating, "It's hard to picture a winner if this goes to the mat." He's pointed out the immense legal costs and the potential for long-term damage to the sport, no matter who wins. He even said, "The whole situation scares me to death." The trial is scheduled to last for about 2 weeks. 9 jurors and 3 alternates will be tasked with untangling this incredibly complex web of business, sports, and antitrust law. They'll hear testimony from some of the most powerful people in motorsports, including team owners, drivers, and NASCAR executives. We're talking about a level of transparency the sport has never seen before. Private emails, negotiation details, and financial data will all become public record. What are the possible outcomes? If the jury sides with the teams, it could be a seismic shift. The court could force NASCAR to make charters permanent, or even fundamentally restructure its entire business model. This would be a massive victory for team owners, giving them the security and asset value they've been fighting for. It would transfer a significant amount of power from the sanctioning body to the teams. However, if NASCAR wins, it would be a major validation of their authority. It would cement their control over the sport and force 2-3 and Front Row Motorsports to either accept the existing charter agreement or potentially face an uncertain future in the Cup Series. It would send a clear message to all teams that NASCAR's authority is absolute. There's also a chance for a settlement. Even with the trial underway, the two sides could still reach an agreement at any moment to avoid a potentially damaging verdict. Many insiders believe this is still a likely outcome, as a jury decision brings a level of unpredictability that neither side may want to risk. A settlement would likely involve some sort of compromise, perhaps a longer-term charter agreement instead of a permanent one, or a revised revenue-sharing model. But regardless of the outcome, this trial is a watershed moment for NASCAR. For decades, the France family has run the sport with an iron fist. This lawsuit is the most significant challenge to that authority in the modern era. The conflict between the independent-minded team owners and the centralized power of the sanctioning body has finally reached its breaking point. This isn't just a legal squabble. It affects everyone involved in the sport. For fans, the future of the racing product is at stake. A healthier financial model for teams could lead to more competition and innovation on the track. But a protracted, ugly legal battle could also tarnish the sport's image and alienate its fan base. For drivers and crew members, their livelihoods are tied to the financial health of the teams they work for. The core of the issue is a philosophical question. Who really owns NASCAR? Is it the family that founded it and has governed it for over 75 years? Or is it the team owners who invest hundreds of millions of dollars to field the cars that fans come to see every Sunday? The answer to that question may soon be decided, not on a racetrack, but in a Charlotte courtroom. This is a story we'll be following very closely. The verdict, or settlement, will have ripple effects for years to come, defining the power dynamics and the economic landscape of NASCAR for a generation. The engines may be quiet in the courtroom, but the stakes have never been higher. Thanks for watching. Don't forget to subscribe for more updates on this developing story and all things NASCAR. We'll see you next time.